Hey everybody, Jonas Callis here of the Hurt at Work Workers' Compensation Law Firm. Many of you know me as the Workers' Comp Guy. First, the obligatory disclaimer. The following information is for informational purposes only and does not constitute legal advice, nor does it create an attorney-client relationship with anyone. So today I want to talk a little bit about a very common issue that injured workers face at some point during their claim. And that is I wanted to talk about, actually, I guess two things, but they're closely related. The first is evidentiary hearings or trials, essentially, in the Virginia Workers' Compensation Commission. And the second, I want to talk very little bit about what's called an on-the-record hearing in the Workers' Compensation Commission. And the on-the-record hearing is also, I would say, commonly referred to as on-the-record position statements. So we're going to talk briefly about that, but I don't think the latter requires much time, actually. So a lot of times injured workers will receive a notice of hearing or a notice of on-the-record position statements in the mail. And they'll wonder, what is this, and why did I receive this from the Virginia Workers' Compensation Commission? So first, I wanted to talk about, when a workers' compensation hearing is necessary, because that kind of will explain why you received the notice of hearing. A workers' compensation hearing or trial is necessary when the parties are unable to reach an agreement on a pending workers' compensation claim or issue. Or an application for hearing that was filed by the employer and or its insurance company. So, for example, an injured worker is seeking an award for lifetime medical benefits, maybe, and has filed timely filed a claim for benefits, seeking those benefits, or for wage loss replacement benefits, such as temporary total disability benefits or temporary partial disability benefits, or some other benefits like permanent partial disability benefits, vocational rehabilitation benefits, mileage reimbursement benefits, anything like that. And the parties, for whatever reason, and there are multiple reasons that can come up, but the parties just cannot agree. Like in this case, obviously the claimant agrees that he or she is entitled to it, right? So in this case, it would be the employer and its workers' compensation insurance company that just cannot agree that either the claimant is entitled to the benefits he or she is seeking, or cannot agree to the exact amount or the time frame or something along those lines. But for whatever reason, they can't agree, right? And when the parties can't agree, that's why there is a workers' compensation commission, right? To sort out, you put before the commission the facts. The commission compares the facts to the law that applies to that situation and comes out with a decision, okay? Parties kind of lose control over it at that point. They just present their facts and hope it comes out in their favor. Or another example. So in that last example, the claimant filed a claim for benefits. Let's say the claimant is in the process of receiving ongoing wage loss replacement benefits or something along those lines, right? And the employer and its insurance company believes that something happened, something changed in the claim that would cause the claimant to no longer be entitled to those benefits. So the employer and its, most of the time when I say the employer and its workers' compensation insurance company, I'm really talking about their defense attorney at that point, right? So the defense attorney files an employer's application for hearing to suspend/terminate those benefits, all right? So in this case, if the parties cannot agree, so in this case, it would be if the claimant does not agree, thinks that they're still entitled to those benefits, or can't agree on the proper date that maybe the claimant says, I'm not entitled to benefits past this date because I returned to work on this date, but the employer thinks he or she returned to work earlier, right? And they can't agree on the date, even though they agree that the benefits should be suspended or terminated. Then if they just can't agree no matter what, that's what the commission's there for, okay? So that's when hearings are necessary. Because a lot of times, especially if you have a good attorney, you can work out these issues, right? You can give the evidence to someone in advance, at least some of it, whatever evidence you think you need to convince them in advance, and maybe you can sort out those issues without even having to go to a hearing or a trial. So, but anyway, that's when hearings and trials are necessary. And in addition to hearings and trials, sometimes on the record position statements. So basically, what is that? Unresolvable disputes, right, over an injured worker's entitlement to benefits, right? That's what causes the need for hearings. So what should an injured worker do then when she or he receives a notice of hearing or a notice of on-the-record position statements? The first thing to do when you open the mail and there's a notice of hearing staring at you or a notice of on-the-record position statements is to see whether, to determine exactly that, right? Is it a notice of hearing with a time and a date and a place to be for an evidentiary trial type hearing, or does it say notice of on-the-record position statement or notice of on-the-record hearing, right? If it says notice of on-the-record hearing, then there is no trial per se, right? So that's the first thing to do is determine what you're looking at. What's coming up, all right? In an on-the-record hearing, no live witness testimony is taken. So there's really no need to meet and convene in front of the deputy commissioner or the administrative law judge, right, to take testimony under oath because there's no testimony taken. What happens is the commission decides the case based on the written statements of the parties, combined with documentary evidence that the parties might submit. Okay. Pursuant to Rule 2.1 of the Rules of the Commission, on-the-record hearings are appropriate when it appears there is no material fact in dispute as to any contested issue. So where all the major facts that would appear to have some sort of influence on the contested issue, when all those facts are kind of more or less in line and there's not a major factual dispute, then it's really just a matter of applying the law to the facts, right? And in that case, the commission will issue a notice of on-the-record hearing, okay, because it believes that you just don't need to waste any more additional time with witness testimony and all that, okay? So, and basically what happens is after each party there's an initial deadline, and then there's 10 days later, typically, there's a responsive deadline. The parties will submit their initial position statements with evidence, documentary evidence, by a certain date, and then 10 days later, they'll have an opportunity to submit another responsive position statement in response to the other party's initial written statement. Okay, so that's how that works. And the commission reviews the evidence and issues an opinion. Usually, they don't take terribly long time, and that's that. So that's a fairly straightforward process, and that's what I was referring to earlier when I said we're not going to spend a lot of time on notices of on-the-record hearing because it's pretty straightforward. Now, sometimes the notice that you get in the mail will say notice of hearing. And that's where there's live evidentiary testimony, witness testimony given and taken at the hearing. In addition to, it's not just the witness testimony, right? In addition to the documentary evidence that may be relevant, okay? Now, you're probably thinking right now, these evidentiary hearings, these trial hearings, these trials, they sound a lot like trials that you may see in movies or on old reruns of Law and Order. And you're exactly right, although without the crowds. These are administrative law hearings. People could come there, I guess. They just don't, not that many people have an interest in spending their time at somebody else's workers' compensation hearing. It is what it is. So there are trials. They're subject to, objection, Your Honor, and that kind of stuff. And sometimes that happens, but there aren't a lot of witnesses, so there's not a lot of that kind of pressure. All right. So to get an idea of, those are the two types of hearings that you could, or two types of things that can happen to adjudicate a claim, right? A disputed claim, on the record or evidentiary. Okay. To get an idea of what I'm talking about some typical issues that are commonly referred to or often referred to the on-the-record hearing docket by the commission are disputes over the correct pre-injury average weekly wage, a disputed request to change workers' compensation doctors, payment of disputed medical bills, permanent partial disability benefits when there are multiple ratings by different doctors as to the extent that the worker is impaired. and also whether the injured worker has returned to work or has been released to return to her or his pre-accident work. Things like that are somewhat straightforward if you just look at the medical records. I mean, they're not always straightforward, otherwise there wouldn't be a disagreement. But, especially with medical issues in the commission, because the commission will often just accept the medical records instead of in lieu of expert testimony, right? So when it's just a medical issue, like, why is there a need for, and sometimes there is, but why would there be a need for whether a doctor has released the worker to go back to work, right? That quite often that can be looked at. You can look at the medical records and medical opinions. So in any event, but on a case-by-case basis, the injured worker may want to offer his or her own testimony as to discussions or something like that, or his or her impressions. In any event, so along those lines, really, if an injured worker receives a notice of on-the-record hearing, but believes that she or he can offer testimony that would be beneficial to those issues, she or he can contact the commission within 10 days of the date on the notice of on-the-record hearing, and request that the matter be set for an evidentiary trial type hearing instead of the on-the-record hearing. In that request, the injured worker should state why. Why do you think this warrants testimony? Like, what testimony, generally speaking, would you add? Okay, so you need to kind of tell them why you think an evidentiary hearing is necessary within 10 days. So, and that's it. So the next step. So that's really kind of the on-the-record hearing issue. Okay. Now, if you open it up and it says notice of hearing, and it's just talking about an evidentiary hearing, the first thing, and this is important, is you have to make sure that you're available at the. It's going to tell you on Thursday, November 21st at 2 p.m. in Richmond, right? It's going to tell you when and where the hearing is. All right. Well, if you're in France at that time, it's going to be hard for you to make a hearing on November 21st. So what do? Well, you don't just sit there and let the hearing pass and not show up for your hearing. Can't do that. Don't do that, okay? What you do is you immediately contact the commission and say, hey, I've had a vacation planned with my family. I'm out of the state. I'm out of the country for that week, whatever, right? Or if it's sooner and not as far off, say, look, I have a different surgery planned. It's been planned for months. I just really can't postpone it again. Can we reschedule the hearing? Blah, blah, blah. Typically, if you do it quickly, those requests are granted. They may advise you to check with opposing counsel, like defense counsel, and you can do that. And typically, they won't object. Even if they do, you can just tell the commission. You can say, I checked with them, they objected, but I can't be at this hearing because I'm be out of the country, or whatever, right? And usually they will reschedule the hearing. But you have to do it properly. You can't wait until 2 days before the hearing when you've had notice of the hearing for 3 months, right? Because then they won't reschedule it, probably. Probably then they will say, no, too bad, you should have told us sooner. So that's important. If conflicts exist, you can get out of it. You just have to be on top of it, okay? Just like everything else pretty much in life. Additionally, here's another one I wanted to mention. The injured worker should check to see that the location of the hearing makes sense. One time I had a worker who was injured. The worker lived in Bedford, was injured around that area, Bedford, Virginia, which is kind of central Virginia. And the hearing, for whatever reason, was scheduled in Williamsburg. So, long story short, we told the commission, not sure why this hearing is scheduled for Williamsburg. It really doesn't have anything to do with Williamsburg. It was just maybe an inadvertent error. So the venue was switched to Rustburg, which is just right outside of Lynchburg, which is way closer to Bedford, right? That way it wasn't as much of an inconvenience on the injured worker or any of the other witnesses, quite frankly. So make sure that the location makes sense. All right. Assuming that the hearing timing and location is appropriate, what next? All right, well, next, you have to review the notice of hearing. And this is true, I guess, for the notice on the record hearings as well, okay? You have to review it to see what issues are scheduled to be dealt with at that hearing or in your written statements or whatever, right? For example, the notice of hearing may list, claim for benefits filed January 1, 2020, and or employer's application for hearing filed February 17th, 2020, okay? It will tell you which things are set to be heard by the deputy commissioner on the date of the hearing, or which things are to be addressed in the written statements. Okay. It's important because once you know what's supposed to be addressed, you can narrow your focus. Like, you can focus on those specific things. Also, the injured worker, if you see that the notice of hearing addresses one claim for benefits and you filed 3 different claims for benefits that address different issues, you may want to, again, sooner rather than later, contact the commission and say, hey, I filed these other claims for benefits as well. I would like for them to be referred to the hearing docket to be heard on the same date as the other claim for benefits. I want them all to be heard together, right? Typically, defense counsels won't object, and most of the time the commission's all for hearing everything together rather than doing it in kind of a piecemeal basis. All right, so now if you look at the notice of hearing, you filed 3 claims for benefits, for example, and it lists 3 claims for benefits, then you're kind of golden there, right? So the next thing is to check and see, look through the rest of the paperwork to see if the deputy commissioner is requiring the parties to complete what is called a pre-hearing statement. Most deputy commissioners anymore require pre-hearing statements, and most pre-hearing statements are due at least 7 days prior to the hearing. Okay, so a pre-hearing statement requests information from the parties. It requests things such as it will request the parties identify the specifics of their claims, what facts are agreed to. These are known as stipulations. What defenses are being raised, what witnesses are expected to testify at the hearing, and whether there is additional evidence is expected that either party may expect to receive after the hearing, even though they've timely pursued it before the hearing. All right, so that's what the pre-hearing statement is. Now, it's important to note that deputy commissioners may dismiss any claim, really, but a lot of times it becomes an issue in injured workers' claims. Okay, they can dismiss the claim entirely, or they can exclude parts of some of the evidence associated with the claim if it hasn't been identified in the pre-hearing statement. So it's very important to complete the pre-hearing statements, complete them timely, and to address the things that need to be addressed in them. Like, look at your claim for benefits, see what you're claiming, make sure that's on there, right? Make sure if you have witnesses, make sure they're listed, right? It's not that hard. You don't even have to in the pre-hearing statement, because here's the thing, right? Most likely you will have been dealing with an attorney on the other side, right? They will have already issued discovery to you. You would have already answered the discovery, and that includes, most of the time, that's going to include, they're going to ask you, identify which witnesses, you intend to call at hearing, and a brief summary of their anticipated testimony. So you will have already done that anyway. So, and on the pre-hearing statement, it doesn't even go into that much detail. You just have to list the witnesses with most of them. So just make sure you do that, because that's important. So the next thing, so you want to review the notice of hearing to find out how much time it's been set for. This isn't as big of a deal, but it can matter. The standard is 30 minutes, so most hearings are automatically set for 30 minutes on the hearing docket. And I realize this is difficult a lot of times it's difficult for attorneys to do, so I understand it's difficult for people who don't specialize in Virginia workers' compensation law to be able to estimate, well, I think my hearing will take longer than 30 minutes. But if things like additional fact witnesses, right? If it's a highly disputed claim and the employer has 2 or 3 witnesses they're going to call, and that you're going to have 2 or 3 witnesses that you want to call, they'll probably request additional time. But if they don't, then you may want to, right? Or if one of your witnesses, maybe the employer didn't depose the witness and they don't understand that the witness is primarily Spanish speaking. Okay, if you know that, and that an interpreter will be needed, then you may want to request additional time, because obviously if you have an interpreter, it's going to take twice as long, right? Like when somebody asks the question has to be interpreted to the witness. The witness answers, that answer has to be interpreted back to the person who asked the question and to the rest of the people in the courtroom. So, things like that require additional time. Just something to know, okay? It'll make you look good, like you're paying attention to your claim. The next thing for the injured worker to do, and this is important. This is like the last thing, the hearing time. Do it if you can. If you can't, But the next thing is pretrial discovery. Can't emphasize enough how important this is. I've mentioned it on my website. We've mentioned it in our other videos. The Hurt at Work workers' compensation law firm cannot stress enough how important discovery is. There are multiple discovery tools that are available to injured workers to gather information and or documentation from the employer and its workers' compensation insurance company that are relevant to the claim. And again, if you probably know all this already if you've reviewed our website and our videos, but this using discovery will allow you to see the strengths and weaknesses of your claim, because again, for one thing, you can ask the employer straight up. You can say, hey, do you dispute the claimant's entitlement to the claimed benefits? If so, please state in detail the reasons why, or your defenses to the claim or something like that, right? So that's going to tell they have to tell you why they're disputing it and why they're denying it, why they think you're not entitled to it, okay? So it kind of lays out for you your strengths and weaknesses, so you'll know where maybe you'll need more evidence and where the evidence isn't so important if they're not disputing something, right? The specific discovery tools, again, you're probably already familiar with this from other things on our website, but interrogatories, requests for production of documents, depositions, requests for admissions, and subpoenas. All of those things are useful, and depending on the circumstances. Check out our website and our other videos for more information on that. And so typically there will be 3 to 4 months between the time the claim is filed and the time that the hearing is scheduled, okay? And so that's plenty of time. That's plenty of time for each party to conduct discovery, so long as you don't wait until the last minute. And yeah, I know that 3 or 4 months can be a long time for an injured worker to go without any kind of income, right? If you're just disabled and out of work and your claim is disputed, they're probably not paying you anything. And 3 to 4 months is a long time to go without any income. But unless you have already been awarded benefits, and this is like a change in condition claim, like a subsequent claim, if you've not already proven your entitlement to benefits and that your accident was compensable, et cetera, then there really is just no way to move the claim up, move the hearing up. It's difficult to do otherwise. So you may be stuck with 3 to 4 months to prepare for your hearing. Now, I bring that up because in some cases, you can actually move the hearing up, but these are rarer, right? It's after you've already been awarded benefits and something has changed. Okay, like you think you're awarded to more benefits, or they think you're not entitled to any more benefits, or something along those lines, right? If you're talking about change in condition applications, then something called an expedited hearing is actually available, where there are severe external kind of real world circumstances that having a hearing sooner may alleviate. Okay, for example, the worker thinks they're entitled to certain additional benefits. The employer disputes it. The worker has been contacted by the bank, said they're going to foreclose on their house, blah, blah, blah. Well, the worker doesn't have money for some reason, right? So maybe moving the hearing up, if the worker wins, then they'll get that money and they'll be able to avoid foreclosure. Something like that, right? Some sort of external pressure that is really, the worker would benefit from having a sooner hearing. But there has to be some reason. You can't just want a quicker hearing. So I think that's all the stuff that you need to worry about around the time you receive the notice of hearing. And actually that last expedited hearing isn't really, I just kind of went off on a tangent there, but that's for change in condition claims. But so now I want to talk to you about what needs to happen leading up to the hearing, okay? As the hearing / trial gets closer, the injured worker should, number one, review the claims that have been filed to make sure that all body parts that they want covered in a lifetime medical award are put before the commission and have been claimed in a claim for benefits, okay? Now, most people, I understand you can be like, well, of course I'm going to claim every body part or whatever. But what happens sometimes is, the worker will file a claim for benefits. In the meantime, they continue to get medical treatment. And then all of a sudden, something that the doctors hadn't realized was an issue earlier, because maybe there was more pain with the worker's other body parts, maybe low back pain and this, that, and the other, right? All of a sudden, the doctor later diagnoses a torn MCL in the knee or something, right? And maybe they didn't put like torn MCL because they were thinking that was radiculopathy from the low back injury, blah, 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 okay? But in any event, so the worker initially claimed low back injury and something else or whatever, right? But not left knee MCL tear, right? So you want to check your pleadings about a month before the hearing to make sure that you've claimed all the body parts that you hurt in the accident, that you've been diagnosed with as having been injured in the accident, okay? So the next thing, at least a month or so before the hearing, the injured worker should check to make sure that he or she has all relevant medical records from all healthcare providers, okay? You will have subpoenaed them already. Maybe you got some of them, most of them, all of them, but you want to make sure that you have them, because the hearing is your chance that's where you have to present your evidence. You need the medical records. That's your medical evidence. If not, you need to follow up with the people or issue a subpoena ducis tecum to the medical provider to make sure that they're aware you need these medical records, okay? Third, similarly, you need to determine about any fact witnesses that that will provide witness testimony at a hearing that is favorable to your claim, okay? Now, once you've determined who those might be, you need to make sure that they're going to be there, right? So a lot of times you want to subpoena them, because if you just ask them, say, hey, you coming to my hearing next, at the end of the month on Wednesday, they'll say, yeah, sure, I'll be there. And then they have no one wants to go to the hearing, right? But if you get to the hearing and you haven't subpoenaed them and they don't show up, a lot of times the administrative law judge or the deputy commissioner is going to look at you and say, we should have subpoenaed them. I understand they told you they were going to be here, but you have to subpoena them. That way, there is some, that subpoenas have some bite, right? It's under penalty, right? So you want to subpoena the witnesses. And here's the thing, like practical matter, right? A lot of these people you're usually on a friendly basis with. So you want to just tell them, say, look, I hate to do this to you, man, but I have to subpoena you. I have to do it to make sure that, I know you told me you're going to be there. I believe you, but I have to subpoena you because for court purposes, for legal purposes, I have to subpoena you. So you're going to get a subpoena. It's just telling you what I already told you that I need you there to testify, right? Just maybe don't blindside them with the subpoena, right? Because then they'll be kind of sore at you maybe if you don't do that. All right, so subpoena them. Begin that process about a month out, because you're going to have to ask a sheriff or somebody to serve that subpoena on them at their address. Fourth thing, the injured worker should make sure that all medical records in her or his possession have been both filed with the Virginia Workers' Compensation Commission and with a copy sent to defense counsel, the opposing counsel, okay? And along those lines, any medical records, if medical records continue to kind of trickle in, right, you need to also, as soon as you get them, file those with the Virginia Workers' Compensation Commission with copies of those medical records sent to defense counsel. You always have to file them with the commission, and you always want to make sure opposing counsel has a copy. That way they can't, because if you don't, and then you get the hearing, they're going to object to it, and then you have to go through that rigmarole. The commission may not exclude the medical records, but they may continue the hearing depending on how many medical records it is. Or they may just offer the defense counsel an opportunity to respond, to have other medical experts respond to those. I mean, it becomes a little bit messier. So, and the thing is, you want to kind of stay away. You don't want to dance the line. You don't want to toe the line of whether your evidence is going to be excluded or not. You want to stay far away from that line. All right, next thing. The day before a hearing or trial, what should you do? Review all of your documentary evidence, right? This includes medical records, accident reports, photographs, surveillance videos, anything else that you want to submit that you think is relevant or that you think you might submit even though you're not sure, all right? Now, think about it. if you've already been answering discovery from opposing counsel, you've probably already sent this to them. Like it's no surprise, you probably already have copies of it and everything. So you just need to look at it and be familiar with the evidence, all right? And we'll get to why in a minute, because you have to authenticate a lot of that. If it's non-medical record evidence, you have to authenticate documentary evidence. But so here's a ninja tip though. Injured workers who are represented by an attorney actually have to file a medical records designation at the hearing pursuant to Rule 2.2. Okay? But when an injured worker is not represented by an attorney, the commission essentially waives that requirement for the injured workers, okay? And they'll just look at all your medical records, all the medical records that are in the commission's file. Hence the importance of getting all your medical records in advance, keeping on top of that, and then supplying them to the commission, right, as soon as you get them, right? That way they have all your relevant medical records. They can make an informed decision. And with everything, okay, with all the evidence that you've already supplied to opposing counsel in discovery, okay, whatever you intend to submit at the hearing, right, you need to have a copy, again, for the deputy commissioner and a copy for opposing counsel, right? It's going to be, this is your trial exhibit, copy of this, right? And you probably want a copy for yourself too, so you can look at it, right? So that's important. All right, so we're at the trial. It's the big day, right? What happens at the trial / hearing? First thing, injured workers should endeavor to arrive 15, 30 minutes early, okay? Don't be late to your own hearing. Just don't do it, right? Just don't do that. That looks so bad. Just don't do it, right? Because a lot of times it'll get dismissed and you have to kind of start the process over again, right? Just don't be late. And it kind of perturbs the deputy commissioners too, right? And that's the one person that you definitely want on your side. You know, defense counsel didn't really, some of them are kind of disagreeable anyway, right? But the deputy commissioner you want on your side, right? So don't be late to your hearing, okay? Particularly if you're in Northern Virginia, if your hearing's in Fairfax or Manassas, or if you're in the Richmond area, you never know what kind of logjam you're going to run into on 95 or 64 or 66. Whether there are going to be any accidents or something like that, okay? So prepare accordingly, right? Make that the one morning that you leave super early to get to something, okay? All right. So near the time the hearing is supposed to start, the bailiff is going to call all the parties in to sit at their tables, right? You'll sit at one table, defense counsel and probably an employer representative will sit at the other table. The deputy commissioner at a certain point, or actually a lot of times the bailiff will do it, but will swear in all witnesses who may testify, right? So it'll be you, the injured worker, but also any other witnesses, both witnesses that may offer favorable evidence for the injured worker and witnesses that may offer favorable evidence against the injured worker and for the employer, okay? All will have to kind of raise their right hand and be sworn in. The whole truth, truth, whole truth, nothing but the truth kind of thing. Then what happens, the deputy commissioner is there. She or he will review the pleadings and the pre-hearing statements that we've timely submitted, right? Confirm with the parties the pending claims to be litigated, confirm whether there are any agreements or, remember, stipulations that the parties have been able to negotiate and agree upon. Deputy commissioner will then usually ask defense counsel to confirm their defenses to the claim. Or if the hearing is if it's a subsequent hearing, say, and you're there that day on the employer's application for hearing, the deputy commissioner may ask the injured worker what her or his defenses are to the claim, to the employer's claim. Defense counsel may hand a copy of their medical record designation that we just talked about, right? Because he or she will be, an attorney, so since the employer will have an attorney, they'll have to file a medical records designation. And they'll hand that to the deputy commissioner and to you. Here's a ninja tip. When the defense counsel hands the injured worker their medical records designation, the injured worker should try to, usually it comes with a cover sheet, like 1, office visit on January 1. Number 2, follow-up office visit on January 19. Number 3, right, it'll have just a brief thing, and then, the first sheet or two will just list briefly what they are. It's like a table of contents. And then the rest of it will be the actual medical records themselves. I mean, if you're familiar enough with your claim, with the medical records, with the things that you've received along the way, you should be able to glance at that and see if there's a new medical record. If they have tried to sneak a new medical record in there that they haven't previously provided to you, you should object to that. They can object to yours, you can object to theirs. If they're trying to sneak a new medical record in that they haven't provided to you before that day, right? Object to it, object to the consideration of the medical record, and alternatively request post-hearing leave or post-hearing permission to respond to that new medical evidence or medical record, okay? Because chances are it may be unfavorable to your claim. Next, if there's a dispute about the wage, the compensation rate or the pre-accident average weekly wage, the deputy commissioner may ask the employer to submit a wage chart, which they are supposed to have already done, I believe, but sometimes they don't until the day of the hearing. So they may ask for that if there's a disagreement about the average weekly wage and no wage chart has been previously filed. In addition, the deputy commissioner may ask the parties if there are any other procedural issues or motions to exclude evidence, like we've talked about in this video, I believe, and also other videos and on our website as well. Typically, right before the hearing is supposed to start, right before the deputy commissioner is ready to begin taking testimony, she or he will exclude the other witnesses from the courtroom so that they can't just sit there and listen and then just kind of corroborate each other, maybe that kind of thing, okay? So she or he won't be excluding them from the trial completely. It's just they'll have to wait outside the courtroom until it's their turn to provide witness testimony, and then they will be called in one at a time to provide whatever additional testimony is needed from them, if any. So that's typically the last thing that happens before the trial actually starts. So I guess that brings us to our next topic. Once the trial/hearing actually starts, how does it proceed? For starters, whoever's claim it is, right, whoever filed the claim that is the reason why everyone's there, has the burden of proof, okay? That's who will go first, all right? So typically, a lot of times if the parties are there on an injured worker's claim for benefits, then the hearing will begin with the injured worker presenting her or his evidence. Well, how does she do that? Well, at a minimum, the injured worker will usually take the witness stand and testify under oath, right? If the injured worker doesn't have an attorney, the deputy commissioner actually will ask questions. And in an effort to bring out whatever evidence she or he feels is relevant to make determinations on the issues. If you remember, I said at the beginning of the hearing, the deputy commissioner will review all the pleadings and the pre-hearing statement, and et cetera, right? So the deputy commissioner will then try to ask questions to pull out from the injured worker, because they also understand that injured workers are not workers' compensation specialists. So they can't help, but they're kind of helping. It's hard to explain. But so they're just trying to ask questions to bring out evidence that can help them make a determination one way or the other. Okay. At a minimum, they'll ask about the following topics: details of the employment, how the accident happened, who the injured worker gave notice to or told about the accident after it happened, the injured worker's medical treatment after the accident, the injured worker's work status and disability since the accident, and possibly the injured worker's job search or marketing efforts since the accident. At the end of the deputy commissioner's questioning, she or he will usually ask the injured worker if there's anything else that he or she wants to add, and you can add it at that time. Then the defense counsel will have a chance to come in and cross-examine the injured worker, right? And some defense counsels are nice people, some aren't. It's just, but typically all of them will ask questions that will likely serve to undermine the injured worker's credibility, right? Inconsistent statements, things throughout the course since the accident, things of that nature. As well as just to bring out facts, maybe previous similar injuries or something that hurts, that will serve to hurt the injured worker's case, that current case. Then, after defense counsel finishes questioning, finishes cross-examination, the injured worker will have another opportunity to add any kind of rebuttal new testimony, not repeating him or herself, but new testimony. All right, so after the injured worker finishes testifying, she or he will have an opportunity to call additional witnesses. So any of those witnesses you brought with you, you'll be able to call them at that point. For example, injured workers will often call maybe family members who, were there before the accident and have been there since the accident, because those family members can testify as to how the accident and the injuries have impacted or affected the injured worker's daily activities at home, right? Or another thing, to the extent the employer contests the accident, right? Says, didn't happen that way, it's not a compensable accident, right? The injured worker may have witnesses that saw the accident or something that say it did happen that way. I was there and I saw it. I saw the last part of it or whatever, right? So those are witnesses that you would want to call to corroborate, right? If you basically have a bunch of witnesses saying the accident happened this way, the accident didn't happen that way, right? So those are just some examples of additional witnesses. All right. Quick ninja tip, and I think I've already touched on this. Injured workers do not need to call or subpoena medical providers, healthcare providers. Healthcare providers will testify in the Workers' Compensation Commission. We talked about the medical records designation. Pursuant to Rule 2.2, medical healthcare providers will testify through their medical records, essentially. So there's no need to call, or go to that expense, because that can be expensive to call medical healthcare providers, doctors, physician's assistants, etc. All right, so after the injured worker finishes calling each and every witness that she wants to offer testimony, right, to the commission, it'll be the employer and its workers' compensation company's turn, or their defense attorney's turn, right, to do the same thing. They'll get to call their own witnesses to testify. And then at that point, the roles will be reversed, right? They'll question their own witnesses. Then the injured worker will have a chance to come in and do cross-examination questions on those witnesses. Then, after the injured worker finishes cross-examination, the attorney for the defense will be able to come in and kind of finish up, right, with what's called redirect examination to any other issues for that witness, and then for the next witness, and then for whatever other witnesses they may have, okay? So as you can see, there's kind of a pattern to it. Now, after defense counsel is done with their witnesses, the claimant will actually have an opportunity to offer additional evidence in rebuttal. It's called rebuttal. This evidence usually needs to be new evidence, not repetitive type things that have already been offered into evidence. And quite frankly, in workers' compensation claims, it's very rare that rebuttal evidence happens. I think it can, but it's pretty rare. One thing I want to be clear of, though, I've gone through this now, and I've told you the order of the trial in terms of who questions who, when they go, and this, that, and the other, okay? All the witnesses and stuff. I haven't mentioned documentary evidence, right? And we've talked about already things, surveillance videos, photographs, accident reports, right? There are things other than medical records that are documentary evidence that you may need to introduce as evidence, okay? These things are introduced via testimony, okay? They're introduced as documentary evidence during witness testimony, all right? So somebody will have to lay, and a lot of times it is the injured worker himself or herself, but somebody will have to lay the foundation. Yeah, I took that photograph. Where'd you take it? I took it at the actual scene where the accident, where they told me the accident occurred. So that's the bottom of that stairwell or whatever, something like that, right? So that way they can say, yeah, I took these 6 photographs. These are all mine, and then you say, I moved to, right, when did you take them, that kind of stuff. I moved to submit these into evidence, that kind of thing, right? You have to have a foundation to submit the evidentiary, the documentary evidence. Otherwise, the deputy commissioner may be required under Virginia law to exclude any of the non-medical documentary evidence that for which a proper foundation hasn't been laid, okay? It is what it is. It goes for both sides, too. And each exhibit must be entered into evidence separately with the proper foundation testimony for each. So that's something to remember. So while you're going through thinking about the witness testimony, you have to make sure that you have your documents accounted for. So what happens after the trial? We're almost done, I promise. What happens after trial? Anymore, the deputy commissioners almost never make a determination right at the end of the hearing, right at the end of the trial. That just doesn't happen that much anymore. Instead, they'll usually issue a written decision called a judicial opinion sometime after the hearing. Sometimes, if it's a really simple issue with fairly straightforward evidence, it may only take a couple of weeks for them to issue a judicial opinion. Other times, if there's more medical evidence and it's a more complicated claim, it can take several months for them to issue a judicial opinion. After receiving a judicial opinion, the parties have an opportunity to do stuff, I guess, right? Well, first of all, so if the judicial opinion is wholly favorable to you, right, to the injured worker, then the injured worker really doesn't have any need to do anything to it, right? You can just sit there. You don't want to challenge it, right? If it's wholly favorable, if it's all of it's favorable to you, you don't want to challenge it. That would be dumb, right? So you're really just kind of waiting and hoping that the employer and the insurance company don't challenge it within the timeline, right, provided. So, but to the extent that the judicial opinion is not favorable to you, maybe parts are favorable, some parts aren't, or maybe none of it's favorable to you. Maybe you lost. What do you do if you lose? Obviously, you could, if it's not a big deal, if it wasn't a big injury. I've had some injuries before where the injured worker just, I don't want to say paper cuts, but just, just not very significant injuries. And sometimes injured workers I've known of injured workers who are just like, I don't really care at this point. Like, they moved on. It was 7 months ago and it really wasn't it turned out not to be a big deal. So some people just accept it for what it is and they just move on. So that's an option, I guess. Of course, the result of not challenging it is that the claim would essentially be closed following the expiration of the appeal period. All right. So otherwise, the injured worker can challenge the deputy commissioner's opinion. First, they could file a request for consideration, asking the deputy commissioner to reconsider the unfavorable opinion and issue a new one. I think the best example of this is when there was a piece of evidence that the injured worker believed to be a key piece of evidence that maybe the deputy commissioner didn't even mention in the judicial opinion, right? And then you kind of, or maybe that one, and maybe they just, or maybe there's a piece of evidence or something that they went one way with it when you think it meant the other thing, right? You can kind of, target those two things or something like that to request reconsideration. A lot of times you lose, but it's worth a request. So now the last thing I want to talk about is the most common thing. The most common thing that happens is the worker may any party who loses really can file a request for review with the full commission. Okay, identifying the specific issues that they think the deputy commissioner got wrong in the opinion. A request for a review is basically you're going up the ladder at that point, right? It's the next step above the deputy commissioner. The judicial opinion by the deputy commissioner will set forth those parameters. Typically, it'll say that the request will need to be made within 30 days of the date of the judicial opinion. And I think that's all I wanted to talk about today with regard to evidentiary hearings and on the record hearings. I've never seen a whole lot on those topics. And to me, those are the things that rear their heads in every claim, right? Because every time, if a claim is disputed, you end up going to hearing at some point. And people who aren't attorneys and who haven't done that before are kind of like a deer in headlights, really. Like, because what do you do? What are you supposed to expect, et cetera, et cetera. So we wanted to put this out there so everybody can kind of feel a little more comfortable about how to approach, evidentiary hearing or an on-the-record hearing, and to know what the difference is. Thanks for watching. I hope it's been helpful. For more information, check out our website, www.hurtatworkinva.com. That's www.hurtatworkinva.com. Follow us on Facebook, YouTube, Twitter. It's chock full of information to help injured workers and to kind of help them know, one, what benefits they may be entitled to, two, how to best go about trying to get those benefits. And the last thing, I'm trying to do my part and to put this information out there in the cyberspace, right? Out there in the world, because I think it's helpful information. So I need everybody else to do their part. Like, if you think this has been beneficial and helpful, if you think our other videos are helpful, if you think our website is helpful, tell your friends, tell your family members, get the word out. Like the whole point, like it's only going to work if both of us are doing our part. If I'm putting this information out there, and if you're sharing it with your friends and maybe talking about it and comparing claims or something to some extent, then I think that's how we win, right? That's how we have a more informed public who can get the workers' compensation benefits they deserve. So I think that's all I got. Until next time, stay safe and don't get hurt at work.